packet, please let me know. Can everybody hear me?
Yes.
All right, fantastic. We're going to get started, 18, and I am going to call up the first bill that's on the agenda. It's House Bill number 1030, and I'm going to recognize the gentleman from Harrison, Representative Flesher, to present the bill. We can't hear you, gentlemen. You're going to have to unmute yourself. We still can't hear you. Is your speaker on? The volume up? All right, so gentlemen, if you don't mind, come up. Are you downstairs in the basement? Come up. Oh, now we can hear you.
Can you hear me? Okay. Thank you, Madam Chair. Sorry about the technical difficulties. House Bill 1030 addresses compensation for student athletes for the use of their name, image, and likeness. Section 1 states that the bill will be titled the Mississippi Intercollegiate Athletics Compensation Rights Act. Section 2 simply defines the terms that will be used in the act. Section 3 expresses that 1, a student athlete may earn market value compensation for the use of their name, image, and likeness while enrolled in a post-secondary educational institution. That a student athlete may obtain a certified agent for any matter related to such compensation. And that a student athlete shall not be an employee or independent contractor of an association, conference, or post-secondary educational school based on the student athlete's participation in the intercollegiate athletics program. Section 4 states that a post-secondary educational institution shall not prevent a student athlete from earning compensation for the use of their name, image, or likeness, and that such compensation shall not affect the athlete's scholarship, financial aid, or related awards and eligibility. Further states that a post-secondary educational institution may impose reasonable limitations on the date and time that a student may participate in a promotion, endorsement, or social media, etc., related to the license or use of the student's name, image, or likeness. Further states that no inducement shall be made for the student's name, image, or likeness in order for the student athlete to attend a particular post-secondary educational institution. In other words, no pay for play. There shall also be no endorsements for tobacco, alcohol, marijuana, gambling, etc. Section 5 expresses that a student must be 18 years or older to enter into such a contract for name, image, and likeness. Section 6 indemnifies the post-secondary institutions from lawsuits or actions resulting from the student's name, image, and likeness agreements. Section 7 further touches on definitions of the bill. And Section 8 finally states that the bill shall take effect on 7/1/2021 if passed. Madam Chair, that completes my explanation of House Bill 1030. I will now yield for questions.
You've heard the gentleman from Harrison's explanation of House Bill 1030. Are there any questions from the gentleman? I don't see any questions from the gentleman. Gentleman from Harrison, I do have a proposed amendment to Section 6 of the bill. And currently, and this is be a conceptual amendment, committee members. Currently, if you're looking at Section 6, it's lines 293 through 305. And the way it reads now, no post-secondary educational institution, athletic association, or conference shall be subject to private cause of action or any claim for damages under this act, including without limitation a claim for unfair trade or competition or tortious interference. And it goes on to talk about the indemnities as the gentleman from Harrison stated. I would like to propose just a conceptual amendment that defines or outlines what a private claim is, that it would be relegated to someone who is actually the student athlete or someone who is involved in the contract, and not persons that are not student athletes are involved in the claim. I think that would help to clarify Section 6. And that is my proposed amendment, and I'll yield for any questions from members of the committee. The gentleman from
Madam-
Athens is recognized for a question.
Yeah, I'm just, this whole section, and I understand it's, the bill, we're working on it, but why do they need that kind of immunity? I mean, it seems to be giving the post-secondary school institution pretty free reign, actually, to interfere if they felt like it. I don't, why do they need that kind of protection?
Well, and that was my concern.
Yeah,
That was
okay,
my concern exactly.
Okay.
Why did they need that kind of protection? And why, if you had a student athlete who actually needed to make a claim, then this language would just simply shut the door on that,
right.
in my opinion. So that was the reason for my proposed amendment.
Okay, good. As long as you got the same apprehension, we'll continue to look at it. Thank you.
Are there any additional questions from members of the committee regarding the amendment?
Madam Chair,
Yes, gentleman from Harrison.
in reading the bill, my understanding was that was more to protect the universities from agreements that they didn't enter into themselves, but because the student was affiliated with the university, they could somehow be held liable. So they were just trying to somewhat indemnify themselves for something that they really had no control over to begin with. Am I wrong in reading it that way?
Well, the way that it reads, if that's the intent, that's not what's clarified here in this language. Number one, very good question. But then also, in addition to that, is that for any student going forward after this legislation passes, if it were to pass, then this language would deny them any cause of action. They would not be able to file anything pursuant to Section 6. And so I want to make sure that that door remains open. We don't want athletes saying, oh, you can use my image, you can use my likeness, in my opinion, but then have any claims barred.
Okay, thank you.
You're welcome. Are there any additional questions from members of the committee regarding the proposed amendment? Seeing none, all those in favor of the amendment say aye.
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 Are there any opposed? Seeing none, gentlemen, the amendment has passed. What is your motion, gentlemen?
My motion is titled sufficient due pass with the accepted proposed amendment.
Amended. All right, you've heard the gentleman's motion, title sufficient due pass as amended. All those in favor say aye.
Aye.
Are there any opposed? Seeing none, the gentleman from Madison moves that we reconsider, and the gentleman from Harrison moves to table. The next item that's on the agenda is House Bill 354. I'm going to call that up. As you can remember, committee, last year, the lady from Forest presented a bill before the committee that dealt with cleaning up of menaced properties. And House Bill 354 is in that same vein. And if you look on lines 195 through 213 of this particular bill of 354, all it's just simply saying is that when there is a violation of a municipal ordinance related to real property, then the judge does have the power to order the defendant to remedy those violations within a certain period of time. And it's within the judge's discretion also to simultaneously authorize the municipality, if the municipality so requested, the option to remedy the violation itself. And the city or the town can use its own employees or with its own contractors without further violation itself and without further notice, should the defendant fail to do so within the time period that was originally set by the judge. Then after the municipality goes in and they remedy the violation, then the city or town, they can petition the judge to assess costs for the cleanup. And then you have on lines 208 through 213, what the judge has to determine that the violations were not remedied by the defendant within a certain amount of time required by the court. The municipality remedied the violation itself after the time period expired, and that the court, that the costs incurred by the municipality were reasonable. And then, as you all know, because everybody on this committee is familiar with these menace property bills and the law, then the costs can be assessed to the defendant as a judgment and then enrolled in the office of the circuit clerk. So that's an explanation of House Bill 354. It does apply statewide toward all municipalities. And so that's an explanation of the bill. I'll yield for any questions from members of the committee. Seeing none, all those in favor of House Bill, my motion is title sufficient do pass. All those in favor say aye.
Aye.
Are there any opposed? The gentleman from Tallahatchie moves to reconsider. Representative Scoggins moves to table. The next bill that I'm going to call up is House Bill number 951. House Bill 951 just authorizes the Department of Human Services to use additional methods of communication when they're sending notices to financial institutions. You'll find the language on lines 53 or 50 through 55. In talking to the Department of Human Services, the approved types of communication, what that would be, primarily would be email. And I inquired just whether or not the financial institutions would accept email, and was actually informed that this was their preferred method now is email. And so this is what would happen in House Bill 951. It's just authorizing the Department of Human Services to use additional methods of communication when they're sending notices related to child support to financial institutions. There is another section that is found in this bill on lines 128 through 132. And what it's doing is revising the term account. I am going to propose, and I'm going to rely on Madam Attorney here, I'm going to propose an amendment to have, pardon? Right, I'm going to want to go back to current law on this, and here's why, committee members. The term account means any money held in the name of the account owner individually or jointly with another, including, and it goes on to expound on what it's limited to or what it's not limited to. And dealing with some of these cases where you have accounts that are held individually or by a joint account holder. As you already know, members of the committee, sometimes the obligor is not on the account by himself or herself. In some instances, I know especially in Southwest Mississippi, in my area, you may have an obligor who is on the account with maybe another relative. And if the obligor is on the account with another relative, or an even probably another example that the committee can identify with, let's say, for instance, if you have spouses who divorce and the ex-spouse may still be on the account with the obligor. Well, what that would mean, Representative Reynolds, the gentleman from Tallahatchie, is that if DHS wanted to come in and encumber or seize those accounts, then even though it's an unintended consequence, the individual who's the adjoint account holder, those funds would be seized and encumbered. In talking to DHS, they recognized, my concern for this language. And what I propose is that we just take this out. If you're wanting to seize or encumber accounts from financial institutions for an obligor, I think at this particular point, it just needs to be the obligor himself or herself. And the way this language is written now, it would actually encompass any account jointly with another. And as you know, for financial institutions, if I was on an account and I also had my husband on an account or a significant other on the account, then it would list both of us as owners. And so for that reason, members of the committee, I'm proposing that we just go back to the original language, but still include the authority for DHS to authorize additional methods of communication. And I will say that the conversation with DHS did go extremely well, and they did recognize the concern with this language. And I'll yield for any questions. Seeing none, I'm going to move title sufficient do pass as amended. All those in favor, say aye.
Aye.
Are there any opposed? Seeing none, the gentleman from Harrison moves to reconsider. The gentleman from Adams moves to table. We have one item that remains on the agenda, House Bill number 1295. And I'm not going to call this particular item up. This has to do with child support and its guidelines. You do have that last bill included in your packet. I have been in communication with DHS on this particular bill as well. And we're not going to call this particular bill up at this time. This concludes the agenda items for this morning's meeting. I would just like to personally thank the members of the committee for your participation in the meeting this morning and also last week. I know things are a little bit different in that we're doing all of our meetings by Zoom, but I do want to thank you. And if there's nothing further to come before the committee, the gentleman from Adams moves that we rise and report progress. All those in favor say aye. Are there any opposed? Thank you.